Welcome. We are visiting features of different aspects of judicial systems in India. One of the basic aspect is the appointment of the judges. The hierarchy of judges is institutionalized under the constitution itself. The constitution is making hierarchy of Supreme Court, High Court, and subordinate courts. Subordinate courts are civil courts and criminal courts. In addition, there are tribunals, quasi judicial authorities, arbitrators of statutory as well as of the optional choice of the party. So let us have a visit to the provisions of the Constitution of India. Article 124 of the Constitution of India provides as a person shall not be qualified for appointment as a judge of Supreme Court unless he is citizen of India and has been at least 5 years a judge of a high court of two or more such courts in succession, or has been for at least 10 years an advocate of the High Court or of two or more such courts in succession, or is, in the opinion of the President, a distinguished jurist. See, this article initially is in a form, person shall not be qualified. That means the qualifications being stipulated here are of mandatory nature. For the appointment of a Supreme Court judge, he is to satisfy the condition. Number one, he shall be at least 5 years a judge of a high court of two or more such courts in succession. Therefore, the first cadre, the first source from which the appointments of the judges of the Supreme Court are considered are the High Court judges, and restriction is only of 5 years. So if one is a judge of High Court for 5 years, then he is qualified to be appointed as a Supreme Court judge. Otherwise, if he has 10 years of practice at High Court, then also he is qualified for the appointment as a judge of the Supreme Court. And the third source reservoir from where the appointments of Supreme Court judges can be made is the pool of distinguished jurists. Here, the adjective given is distinguished to jurist. So one is to be a jurist, and secondly, he should be distinguished jurist. Now, one may have a pause here and think, who are jurists? All academicians cannot be taken as jurists. And then, who are distinguished jurists? This again will be a question which will be of open evaluation. And this is being mentioned here in the opinion of the President. So, one who is a distinguished jurist in the opinion of the President of India is qualified to be appointed as Supreme Court judge. So far, this third reservoir option has not been exercised. No person has been appointed as a judge of the Supreme Court in the category of distinguished jurists. The first two categories And of these two as well, as far as the second category is there, the appointments directly from the advocates as well is a few. The most option is the first reservoir, that is of the High Court judges. In a way, it can be said that the appointment of High Court judge as Supreme Court judge is his elevation. It is so, it is said, High Court judge is elevated as Supreme Court judge. Now, these conditions, as these are, take us to the most favorable choice being of the High Court judges. So, High Court judges are the biggest reservoir from where the elevations is made to the Supreme Court. Article 217 provides for the appointment and conditions of the office of the Judge of a High Court. Now, see, the word used is appointment and conditions of the office of a Judge of a High Court. The word used here is office of the Judge of a High Court. However, as far as the Article 124 is there, it is appointment as Judge of a Supreme Court. Here it is that it is a provision of appointment and conditions of the office of the Judge of a High Court. It reads as, every Judge of a High Court shall be appointed by the President by warrant under his hand and seal on the recommendation of the National Judicial Appointment Commission referred to in Article 124A, and shall hold office in the case of an additional or acting judge as provided in Article 224, and in any other cases until the attainment of age of 62 years. Therefore, the conditions and appointment aspect has been now subjected to the recommendations of the National Judicial Appointments Commission. This provision of National Judicial Appointments Commission is the aspect which has been debated, and ultimately it has been accepted as a proper judicial apparatus. Supreme Court has adjudicated and come to the conclusion of the National Judicial Appointment Commission's situations, powers, opportunities, values, and many aspects attached with it. It is a very big constitutional question. It is very big constitutional interpretation phase through which we have passed, and there is a continuous debate over it. Therefore, the constitutional provisions as far as the Supreme Court judge and High Court judge are concerned, or as these are here. In addition, the Constitution in Article 233 provides for appointment of district judges. The appointment of person to be and the posting and promotion of district judges in any state shall be made by the governor of the state in consultation with High Court exercising jurisdiction in relation to such state. A person not already in the service of the Union of the state shall only be eligible to the appointment appointed a district judge. He has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for the appointment. Therefore, as far as the appointment of district judges is concerned, it, as per the Constitution, is to be as per the recommendation of the High Court. As far as the High Court judges are concerned, there is a National Judicial Commission provision. Now, in practice, this recommendation of the High Court is on the basis of the success in the competitive examination. So, as far as the subordinate judiciary up till the level of district judges, session judges is concerned, same is a secular democratic exercise where there is a open competitive examination selection process, and those who are in merit, who are in that limit of the vacancies, becomes the basis for taking it to be, it is the recommendation of the High Court. So recommendation of the High Court in practical terms stands reduced to conduct a competitive examination. Therefore, this process of recommendation of the High Court in the form of conducting a open competitive examination and the vacancies to be recommended to be filled as per the merit of the concerned competitive examination. The other provisions of appointments of tribunals, quasi-judicial authorities, etc., take us to the relevant parliamentary statutes. Therefore, the judicial system in India is in hierarchical ladder is Supreme Court and the High Court, and then there are the subordinate courts, tribunals, etc. Advocates shall consider it an open option to be in the judicial service up till the subordinate courts level. The appointment is through open competitive examination. So one is to prepare as per the standards fixed. As far as the appointments to High Court and Supreme Court are concerned, for that there is no such open merit selection competitive process. Same is left to the wisdom of the recommending and selecting authorities. Therefore, it may be debatable as that the appointments beyond subordinate courts level is not as secular, democratic, and open as the appointment process of the subordinate judiciary is concerned. The aspect which I am focusing now is that 35 years age is the yardstick accepted by the Constitution for the maturity of the individual, which makes him capable for being appointed at all levels of the judicial system in India. So we shall plan ourselves, we shall evaluate ourselves, we shall prepare in such a way that as far as the law domain is concerned, the justice domain is concerned, we shall perfect our maturity up till the age of 35 years. Now, normally, the law graduation is complete up till the age of 21 to 22 or 23 years of age. After graduating, after obtaining a law license practice, we shall plan ourselves for our maturity as well. We shall, while or in practice, shall not ignore our academic excellence aspect, how we will enrich our experience, how we will perfect our maturity, how we will perfect our experience based wisdom depends upon us. Each one of us shall plan our 10 years period, means the first 10 years of practice be taken as a period for perfection of maturity, perfection of intelligence, perfection of the wisdom, which shall be of the level of the constitutional expectations for entrustment of the responsibilities of judicial courts up till the Supreme Court. For it, we shall enter upon a course of self-study, self-evaluation, self-introspection, and this process of self-evaluation shall be a continuous process. Each day, each week, each month, each year, we shall evaluate ourselves, we shall get evaluated ourselves, so that within a period of 10 years, we have successful attainment of the level of maturity, enrichment of knowledge, the level of wisdom which is as per the expectation of the Constitution of India. The Constitution of India expects the legal jurisprudential maturity of such intensity and degree that the responsibilities of the office and court of Supreme Court, judge, office and court of the High Court judge, office and court of district and session judge can be discharged properly. We shall invent our own timetable. We shall manage our own time. We shall manage our own programs of being on a sequential progression path. It all will depend upon one himself. The success or failure during these 10 years, first 10 years of practice, will charter the subsequent phase of practice and life both. We know that under Advocates Act, there is a uniform pool as an advocates. However, High Courts and Supreme Court is having a practice of accepting some of the advocates as senior advocates. And one realistic aspect is that one who becomes a senior advocate at High Court or Supreme Court level is of the constitutional maturity of the order of discharge of the responsibilities of the office of the court of High Court and Supreme Court judge. One shall plan one's practice period in such a way that one successfully becomes a senior advocate and one is of maturity of the order of the Constitution for discharge of the responsibilities of the High Court judge. Thank you very much.